The air in Judge Andrew H. Stone's courtroom was thick with tension, an invisible force pressing down on every person present. It wasn't just another day in federal court. This was a collision of power, principle, and raw justice. At the center of it all stood Congresswoman Jasmine Crockett, a woman who had spent her life fighting for people like herself, those too often dismissed by institutions that claimed to serve them. She wasn't here to play politics or stage a spectacle. She was here to expose a pattern of judicial misconduct that had gone unchecked for far too long. Judge Stone, a man who had ruled his courtroom with an iron grip for over 2 decades, believed he was untouchable. His smirk, as he addressed Crockett, betrayed years of arrogance, a lifetime of privilege that had shielded him from accountability. But what he didn't know, what no one in that room could have predicted, was that Crockett had come prepared, not just with legal arguments, but with a meticulously crafted case against the judge himself. What followed was not just a courtroom battle, it was a reckoning. In the span of 30 seconds, the balance of power shifted, a moment that would later be replayed millions of times across social media, dissected in law schools, and debated in newsrooms around the world. Because this wasn't just about a single lawsuit, it was about whether the American justice system could truly hold itself accountable. And at the heart of it all was Jasmine Crockett, a woman who refused to back down when faced with institutional bias. The man behind the bench judge. Andrew H. Stone's was not just any federal judge. He was a living embodiment of the old guard, a relic of a time when the judiciary was seen as an exclusive domain for men like him. Born into wealth, raised with privilege, and molded by elite institutions, Stone's had never known struggle. He graduated from Harvard Law School, clerked for a Supreme Court justice, and spent decades presiding over cases where his word was final. To him, the law was not about justice. It was about tradition, control, and maintaining the status quo. His courtroom reflected his worldview, austere, imposing, and steeped in history. The portraits lining the walls were all white, all male, all part of a legal lineage that excluded anyone who did not fit their mold. For Stone's, the Constitution was not a living document meant to evolve with society. It was a rigid structure to be interpreted through the lens of precedent set by those who came before him. He had built a reputation as a strict enforcer of courtroom decorum, quick to dismiss cases he deemed frivolous, and even quicker to silence voices that challenged his authority. But beneath the polished veneer of professionalism lay something more insidious, a deep-seated resistance to change, particularly when it came to civil rights. Over the past 5 years, numerous attorneys had quietly complained about his handling of such cases. They spoke in hushed tones about how he routinely dismissed evidence of voter suppression, laughed off claims of systemic discrimination, and made condescending remarks toward plaintiffs who dared to challenge powerful institutions. Some had even accused him of outright bias, though few had the courage or the resources to take action. What most people outside the legal community didn't understand was that federal judges like Stone's operated with near total impunity. Their lifetime appointments insulated them from public scrutiny, and the mechanisms in place to hold them accountable were slow, bureaucratic, and often ineffective. Unless someone was willing to directly challenge a judge in open court, an act that carried immense risk, there was little recourse for those who felt wronged by their rulings. That was exactly why so many lawyers avoided confrontation with Stone's. Challenging a federal judge could mean professional retaliation, reputational damage, or even disbarment if the judge chose to retaliate. Most attorneys learned early on that survival in the courtroom required knowing when to fight and when to retreat. But Jasmine Crockett was not most attorneys. She had spent years defending clients in courts just like this one, watching as judges dismissed their struggles, questioned their credibility, and upheld systems designed to keep them powerless. She knew the risks better than anyone, but she also understood something else. Sometimes, the only way to dismantle injustice was to stand up to it head-on. Jasmine Crockett was not born into privilege, nor did she inherit a legacy of power. She was the product of working-class neighborhoods in St. Louis, where opportunities were scarce and systemic barriers abundant. From an early age, she understood what it meant to fight for justice, not as an abstract ideal, but as a daily necessity. Her mother worked double shifts to put food on the table, and her father, a former factory worker turned union organizer, instilled in her the belief that standing up for what was right was not optional. It was essential. Those lessons shaped her path, leading her to law school not because she sought prestige, but because she wanted to give a voice to those who had been silenced. Unlike many of her peers who entered law school with generational wealth and connections, Crockett paid her own way, juggling multiple jobs while excelling academically. She graduated top of her class, but instead of chasing corporate law or prestigious clerkships, she went straight into the trenches. As a public defender, she fought for clients whom the system treated as expendable, people who couldn't afford representation, who were dismissed by judges who saw them as statistics rather than human beings. She learned quickly that the courtroom was not always a place of impartial justice. Too often, it was a battlefield where power dictated outcomes, where bias cloaked itself in legal language, and where the rules seemed to bend differently depending on who was sitting at the defense table. It was in these battles that Crockett honed her skills. She became known for her relentless preparation, her ability to dismantle flawed arguments with surgical precision, and her refusal to back down in the face of authority. She didn't just memorize case law, she lived it, understanding not just what the law said, but how it was weaponized against the vulnerable. When she eventually transitioned from practicing law to running for office, she brought that same fire with her. She didn't campaign on empty promises or political theatrics. She ran because she knew the system needed real change from someone who had seen its failures firsthand. Her election to Congress was not a fluke. It was the culmination of years of tireless advocacy. She represented a new generation of lawmakers unafraid to challenge entrenched power, and her presence in Washington was met with both admiration and resistance. Conservatives criticized her for being too aggressive, while some within her own party urged caution, warning that direct confrontations with the judiciary could be politically risky. But Crockett had never been one to play it safe. She understood that true progress required boldness, and she was ready to bring that same courtroom tenacity to the national stage. When she learned that Judge Stones had been assigned to oversee a critical voting rights case, one that involved evidence she had personally helped gather, she knew this was more than just another hearing. This was a chance to expose a pattern of judicial misconduct that had gone unchecked for years. While others might have hesitated, fearing retribution or career consequences, Crockett saw it for what it was, a moment of reckoning. She had spent her entire life preparing for this fight, and she wasn't about to let fear dictate her actions now.
At first glance, the lawsuit should have been routine. A civil rights case alleging voter suppression in Texas, the kind that rarely made headlines and even more rarely led to sweeping reforms. But this case was different. It wasn't built on speculation or broad accusations. It was backed by concrete, irrefutable evidence of systematic disenfranchisement. Crockett had played a direct role in gathering that evidence during her time as a civil rights attorney, combing through records, speaking with affected voters, and documenting patterns of discrimination that pointed to a coordinated effort to suppress minority turnout. Now, as a congresswoman, she was back in court not as an attorney, but as a plaintiff's advocate determined to ensure that justice would not be denied. The stakes were higher than most people realized. This wasn't just about one lawsuit. It was about whether the federal courts would continue to serve as a bulwark against civil rights violations, or whether they had become yet another institution complicit in protecting the status quo. If Judge Stones dismissed the case, it would send a message that courts could ignore documented discrimination without consequence. If he allowed the evidence to be heard, it could lead to landmark rulings that force states to reform their election practices. The outcome would ripple far beyond Texas, influencing future litigation and shaping the legal landscape for years to come. Crockett knew all of this going in. She had studied Stones's judicial record, reviewed his decisions in similar cases, and spoken with attorneys who had appeared before him. She knew his tendencies, how he dismissed evidence that threatened established norms, how he belittled plaintiffs who dared to challenge powerful institutions, how he used procedural technicalities to sidestep substantive rulings. More importantly, she knew that if she approached this case like any other lawyer, she would lose. She needed to do something unprecedented. She needed to do something unprecedented. She needed to turn the tables, not just argue the merits of the case, but expose the very judge overseeing it for the pattern of bias he had perfected over 2 decades. She spent months preparing, assembling a dossier of his rulings in civil rights cases, collecting transcripts of his courtroom interactions, and identifying the specific moments where his behavior crossed the line from skepticism to outright prejudice. She knew that challenging a sitting federal judge in open court was dangerous. Most attorneys wouldn't dare, fearing retaliation, sanctions, or even disbarment. But Crockett wasn't just any attorney, and this wasn't just any case. She wasn't there to win a single trial. She was there to make a statement that would echo through the legal world for generations. As she stepped into Judge Stones's courtroom, she knew what was coming. The smirk, the dismissive tone, the calculated interruptions, all of it was predictable. But what wasn't predictable was what happened next. Because Jasmine Crockett wasn't just there to defend a lawsuit. She was there to dismantle a legacy of judicial arrogance piece by piece, using nothing but facts, law, and an unshakable belief in justice. From the moment proceedings began, it was clear that Judge Stones intended to assert control over the courtroom and over Jasmine Crockett. His demeanor was laced with condescension, his words carefully chosen to undermine her authority. He mispronounced her name deliberately, calling her Congresswoman Crockett, despite repeated corrections. It was a small but telling act of disrespect, one that signaled his intention to diminish her presence rather than engage with her arguments. Every time she attempted to speak, he cut her off mid-sentence, allowing defense attorneys to interrupt freely while silencing her with a mere glance. When she cited recent civil rights precedents, he rolled his eyes, dismissing them as irrelevant. Crockett remained composed, her voice steady and professional as she delivered her opening statement. "Your Honor," she said, laying out the core of their case, "the evidence will show a pattern of systematic voter suppression that violated the constitutional rights of over 50,000 Texas residents." It was a straightforward declaration, grounded in fact, but Judge Stones responded with a smirk. "Congresswoman Crockett," he drawled, emphasizing the incorrect pronunciation once again. "These are serious allegations. I trust you have more than political rhetoric to support them." The courtroom stirred at his tone. But Crockett didn't flinch. She knew this was just the beginning. When she presented documentation, showing the closure of polling places, in predominantly black neighborhoods, Stones questioned its relevance. When she introduced statistical analysis proving discriminatory impact, he called it speculative. Each objection was sustained without hesitation, each opportunity for evidence to be heard swiftly shut down. Then came the moment that would ignite the firestorm. Crockett attempted to introduce video footage from 3 different polling locations, showing poll workers turning away eligible voters. "Your Honor," she announced, holding up a tablet, "we have security footage from 3 different polling locations showing poll workers turning away eligible voters." The defense attorney immediately objected. "Prejudicial and inflammatory," he declared. "Sustained," Stones ruled without looking at the evidence. "Move on, Congresswoman." Crockett's jaw tightened. "Your Honor, this is direct evidence of—" "I said move on," Stones interrupted, his voice carrying the weight of decades of courtroom authority, "unless you have something more substantial than amateur videos." The courtroom fell silent. Reporters exchanged glances. Defense attorneys looked surprised at how dismissive Stones was being. But Crockett wasn't backing down. She took a breath, steadying herself. "Your Honor, with respect, this evidence is central to our case. These amateur videos show constitutional violations in real time." That was when it happened. Judge Stones laughed. Not a polite chuckle, not a brief expression of amusement, but a full-bodied, condescending laugh that echoed through the courtroom like a slap in the face. "Congresswoman," he said, still chuckling, "I've been on this bench for over 20 years. I've seen every trick in the book. Cell phone videos and political grandstanding might work in Congress, but this is a court of law. Real law, not whatever they're teaching in political science classes these days." The silence that followed was deafening. No one moved. No one breathed. And then, something changed in Crockett's eyes. The mask of professionalism slipped, revealing something deeper: controlled fury, sharpened by years of witnessing injustice. She didn't raise her voice. She didn't lash out. Instead, she calmly asked to approach the bench. "That won't be necessary." Stones waved her off dismissively. "Let's move on to your next political point." But Crockett didn't move. Instead, she reached into her briefcase and pulled out a thick folder that seemed to materialize from nowhere. "Your Honor," she said, her voice now carrying a steel edge, "before we continue, I believe there are some procedural matters the court needs to address." Stones's smirk faltered slightly. Something in her tone had shifted, and experienced courtroom observers could sense that the dynamic was about to change completely. "What procedural matters?" he asked, his voice betraying the first hint of uncertainty. Crockett opened the folder, the sound of papers rustling seeming to echo through the silent courtroom like thunder. "Well, Your Honor," she began, her voice now carrying the confidence of someone who had just played their ace card, "it seems we need to discuss your pattern of behavior in civil rights cases over the past 5 years.
Crockett's voice cut through the courtroom like a blade, sharp and unwavering. "Your Honor," she began, flipping through the pages in front of her, "I'd like to take this opportunity to review some of your past rulings, specifically in civil rights cases." The judge's smirk faded entirely now, replaced by a flicker of unease. He gripped his gavel tighter, knuckles whitening, but said nothing. Crockett continued. "Let's start with Morrison versus Texas Secretary of State from 2023. A voting rights case remarkably similar to this one." A murmur rippled through the gallery. Reporters leaned forward, scribbling notes furiously. Defense attorneys exchanged uneasy glances. Crockett pulled out a transcript and held it up for the court. "According to the court record, Your Honor told the plaintiff's attorney, maybe stick to personal injury cases and leave constitutional law to people who understand it." Gasps filled the air. The audacity of the remark was undeniable. Judge Stones tried to regain control. Congresswoman, this is highly irregular. Crockett didn't miss a beat. What's irregular, Your Honor, is a federal judge who has systematically violated judicial ethics in civil rights cases for the past 5 years. Her voice was calm, measured, but the weight behind her words was unmistakable. Shall we continue? Before the judge could respond, she moved on. Henderson v. Texas Board of Elections, 2022, another voting rights case. You dismissed it outright, then sanctioned the attorneys for bringing what you called a frivolous lawsuit designed to generate media attention. She flipped to another page. The Fifth Circuit Court of Appeals overturned those sanctions, finding your behavior inappropriate and potentially biased. Did you ever apologize to those attorneys whose reputations you tried to destroy, Your Honor? Silence. No response. Crockett pressed forward. Williams v. Texas Department of Public Safety, dismissed with prejudice after you called the evidence political theater, later reversed on appeal. Jackson v. Harris County Elections, you told the plaintiff's attorney to stop wasting the court's time with conspiracy theories, also reversed on appeal. Thompson v. Texas Legislature, you suggested the plaintiff find a hobby other than suing the state, reversed on appeal and resulted in a formal reprimand from the Judicial Conduct Board. With each case, the atmosphere in the courtroom grew heavier. Reporters were no longer just taking notes, they were recording every word, knowing they were witnessing history. The defense team whispered urgently among themselves, realizing that their client's victory was slipping through their fingers. But Crockett wasn't finished. And then, Your Honor, we have the most interesting case of all. Davis v. Texas Attorney General, 2021. She paused, letting the weight of the name settle over the room. Do you remember that one? Judge Stones's voice was barely a whisper. That case was, Crockett interrupted smoothly. During the proceedings, Your Honor made some very interesting comments that were recorded and transcribed. She pulled out a final document, marked with official court seals. You told the plaintiff's attorneys, these people need to stop complaining about every little rule and learn to follow the law like everyone else. The courtroom erupted. The phrase, these people, carried implications that could not be ignored. Crockett let the outrage settle before delivering the final blow. That case was also reversed on appeal, and the appeals court didn't just reverse your decision. They referred your conduct to the Judicial Conduct and Disability Committee for investigation. Judge Stones looked like he had seen a ghost. That investigation was inconclusive. Crockett smiled thinly. Yes, it was. Because investigating sitting federal judges is a lengthy process, but I imagine that investigation might be reopened if new evidence of a pattern of bias were to emerge. She gestured to the pile of documents on her table. New evidence like, say, 12 documented cases of inappropriate behavior in civil rights cases. New evidence like a federal judge laughing at constitutional violations. New evidence like a pattern of bias so clear that even a first-year law student could see it. The silence that followed was deafening. Judge Stones sat frozen, realizing that his career, his reputation, and his legacy were crumbling in real time. But Crockett wasn't done. Your Honor, I'd like to make a motion. Her voice carried across the silent courtroom like a bell tolling. I move that this court recuse itself from this case due to demonstrated bias and prejudice against civil rights plaintiffs. I further move that this case be transferred to a judge who can evaluate the evidence without the burden of a documented history of inappropriate conduct in similar cases. She paused, letting the words sink in. And Your Honor, I respectfully suggest that you might want to consider whether continuing to preside over civil rights cases is in the best interest of justice, given the overwhelming evidence of bias I've just presented. The courtroom exploded into chaos. Reporters rushed for the exits to file their stories. The defense attorneys huddled together in emergency consultation. Court staff whispered urgently among themselves. And Judge Andrew H. Stones, the man who had spent 20 years believing he was untouchable, sat in his chair, staring at the woman who had just ended his career with nothing but legal research and the truth. Crockett calmly gathered her documents, placed them back in her briefcase, and waited for his response. The fallout begins. The silence in Judge Stone's courtroom stretched unbearably as the weight of Jasmine Crockett's words settled over everyone present. The air was thick with disbelief, anticipation, and the quiet hum of adrenaline. Then, finally, the judge spoke, his voice weak, almost hollow. Court is in recess. We'll resume tomorrow morning." His gavel tapped once, a feeble attempt at restoring order, but the sound barely registered over the rising tide of murmurs and movement in the courtroom. Reporters bolted for the exits, phones already in hand, desperate to be the first to break the story. Within minutes, snippets of Crockett's takedown began circulating online. Video clips captured her calm, yet commanding delivery, juxtaposed with Judge Stone's visible distress. The hashtag #, Crockett's courtroom confrontation, trended on social media before the courthouse doors had even closed for the day. TikTok users edited dramatic music behind her most impactful lines, while Twitter threads dissected the legal implications of her motions. Inside the courtroom, the defense attorneys scrambled, whispering urgently among themselves, trying to assess the damage. They had expected to counter Crockett's arguments about voter suppression, not defend against accusations of judicial misconduct. The implications were staggering. If Crockett's motion for recusal was granted, their entire strategy would be thrown into disarray. Worse still, the judge himself was now under intense scrutiny, and if the case was reassigned, the new presiding judge might not be as inclined to dismiss Crockett's evidence. Outside, the legal community was already reacting. Prominent civil rights attorneys flooded their social media feeds with praise for Crockett's performance. "This is what accountability looks like," tweeted one prominent lawyer. "For years, we've seen judges dismiss civil rights cases based on bias masked as legal reasoning. Today, someone finally called them out in open court." Others were more cautious, noting that while Crockett's argument was compelling, the process of formally removing a federal judge from a case was complex and could take weeks, even months. By evening, major news outlets had picked up the story. CNN's legal analyst, Jeffrey Toobin, called it one of the most effective pieces of courtroom advocacy I've seen in 30 years of covering the law. Fox News legal contributor Judge Andrew Napolitano, despite his conservative credentials, admitted, "Crockett's research was impeccable, her presentation flawless, and her legal arguments unassailable. This is how the system is supposed to work." Even the New York Times published an op-ed titled, "When a Judge Falls, the Power of Legal Accountability," analyzing the broader implications of Crockett's motion. Meanwhile, the Dallas Morning News launched an immediate investigation into Judge Stone's judicial record, publishing a timeline of controversial rulings stretching back over a decade. The Texas Tribune revealed that they had been compiling similar reports for months, but had struggled to find sources willing to go on record. Now, with Crockett's testimony and the mounting pressure from the media, whistleblowers began stepping forward, sharing accounts of unfair treatment and biased rulings. Jasmine Crockett's courtroom triumph was more than a legal victory. It was a catalyst for change. In the days following the dramatic showdown, legal professionals, civil rights advocates, and ordinary citizens alike recognized the significance of what had taken place. For years, attorneys had whispered about biased judges, shared stories of unfair rulings, and lamented the lack of accountability in the federal judiciary. But Crockett had done something unprecedented. She had taken those complaints and transformed them into an undeniable, well-documented case of judicial misconduct. Legal scholars and practitioners began referring to her strategy as the Crockett Protocol, a methodical approach to exposing patterns of bias in the judiciary. Law students pored over the transcripts, analyzing how she had meticulously compiled a decade's worth of rulings, identified recurring themes of prejudice, and presented them in a way that left no room for dismissal. Professors at prestigious law schools incorporated her courtroom performance into their curricula, teaching future attorneys how to challenge judicial misconduct without falling into procedural traps. Beyond academia, Crockett's actions inspired a wave of grassroots activism. Civil rights organizations launched initiatives to track and report biased rulings, encouraging attorneys to compile data on judges who consistently dismissed civil rights cases or exhibited discriminatory behavior. Online platforms emerged where individuals could submit testimonies about their experiences in court, creating a database of potential misconduct that could be used to hold judges accountable. Perhaps most significantly, Crockett's success emboldened other attorneys to speak out. Across the country, lawyers who had previously feared retaliation for questioning judicial bias began filing motions for recusal based on patterns of misconduct. Courts that had once dismissed such requests as baseless now had to contend with a growing body of evidence demonstrating that judicial bias was not merely anecdotal, it was systemic. The ripple effect extended into legislative chambers as well. Crockett's congressional colleagues, many of whom had watched the courtroom drama unfold in real time, recognized the urgency of judicial reform. Within weeks, bipartisan discussions began on Capitol Hill regarding measures to increase transparency in the federal judiciary. Proposals included mandatory bias training for judges, standardized reporting requirements for judicial misconduct, and clearer procedures for recusal in cases involving potential conflicts of interest. Even members of the opposition party, who had initially dismissed Crockett's actions as political posturing, found themselves unable to ignore the overwhelming evidence of judicial misconduct. Conservative legal commentators, typically wary of challenges to the judiciary's independence, acknowledged that the system needed checks and balances. Some even admitted that Crockett's approach, grounded in thorough research and legal precedent, set a new standard for accountability. As the conversation expanded, Crockett remained focused on the broader implications of her victory. In interviews, she emphasized that this was not about one judge or one case. It was about ensuring that the legal system served all Americans equally. Justice isn't just about laws on paper, she told the New York Times. It's about how those laws are applied in practice. If we don't hold judges accountable when they fail to uphold constitutional principles, we erode the very foundation of our democracy. The movement she had ignited was no longer confined to courtrooms or legal circles. It had become a national conversation about fairness, transparency, and the responsibility of the judiciary to serve the people, not just those in positions of power. A legacy. Etched in Justice Jasmine Crockett's courtroom victory was more than a singular moment of triumph. It was a defining chapter in the ongoing struggle for justice in America. Her meticulous research, unshakable resolve, and fearless advocacy had exposed a deeply entrenched pattern of judicial bias that many had long suspected, but few had dared to challenge. By standing up to a powerful federal judge and forcing the legal system to reckon with its own flaws, she had not only secured justice for the plaintiffs in her case, but had also reshaped the way future attorneys, judges, and lawmakers would approach issues of fairness and accountability. Her impact extended far beyond the confines of that courtroom. In the months that followed, legal scholars dissected her strategy, refining it into a blueprint for holding biased judges accountable. Young lawyers, particularly women and minorities, found inspiration in her example, seeing proof that expertise and courage could overcome even the most entrenched power structures. Civil rights organizations adopted her methodology, creating databases of judicial misconduct and pushing for reforms that would prevent similar abuses from going unchecked in the future. But perhaps the most profound legacy of Crockett's actions was the message it sent to those who had long believed themselves untouchable. Judges who had grown comfortable dismissing civil rights cases, making condescending remarks from the bench, or shielding discriminatory policies behind procedural loopholes, now faced a new reality, one where their decisions could be scrutinized, their biases exposed, and their careers held accountable. The idea that federal judges were above criticism had been shattered, and in its place, a new era of judicial transparency had begun to take shape. Yet, for all the recognition and accolades that followed, Crockett remained steadfast in her mission. She did not seek fame or political capital from her victory. Instead, she used her newfound platform to push for broader reforms, mandatory bias training for judges, improved mechanisms for reporting misconduct, and greater oversight of judicial conduct. She reminded the nation that justice was not a passive concept, but an active pursuit, one that required vigilance, courage, and an unwavering commitment to truth. As her story spread, it became more than just a legal case. It became a symbol of how the system, though imperfect, could still be wielded as a tool for justice when placed in the hands of those willing to fight for it. And in the end, that was the greatest victory of all. A call to action. Jasmine Crockett's courtroom victory was more than just a legal milestone. It was a reminder that justice doesn't happen by accident. It happens when someone dares to challenge the status quo, when someone refuses to accept injustice as the cost of doing business. Her story proves that one person, armed with knowledge, preparation, and moral courage, can change the course of history. But it also raises an important question. How many more unjust rulings have gone unchallenged simply because no one had the courage to speak up? If you believe in a justice system that serves everyone, not just those in power, then it's time to take action. Support legal organizations that fight for judicial accountability. Encourage transparency in the courts by advocating for reforms that make it easier to report and investigate judicial misconduct. Share stories like Crockett's to remind people that the law is not just a set of rules. It's a living force that must be defended by those willing to stand up for what's right. Don't forget to subscribe and hit that notification bell so you never miss moments when justice gets served and truth wins out over institutional power. The next time someone tells you that one person can't make a difference in the system, remember the day Jasmine Crockett walked into Judge Stone's courtroom and changed American jurisprudence forever.